Good afternoon. My name is Alina Shevtsova. I am an immigration attorney from Brooklyn, New York. In this legally speaking seminar, I'm going to talk about how to remove a condition from your green card. Those of you who are going to marry or who are married to US citizens are likely to file for green cards, application for permanent residence in the United States. And once that application is granted on the date that is earlier than the second anniversary of your marriage, you will receive only a conditional green card. It means that the government will still require you to file one more application before you receive your permanent green card. That application is known to be Form I-751, application to remove conditions on one's permanent residency. Why is it done this way? The idea was many years ago is that to prevent immigration fraud, the government has to make sure that the couple still in fact married and spouses reside together and they still are in viable or real and still ongoing marital union. What's going to happen is that approximately 4 months prior to the expiration on your green card, you're going to receive a notice from the government stating that within 90 days from before the second anniversary on your green card, you need to file together with your spouse a joint application to remove condition from the green card. What happens if you miss this deadline? Let's talk about this first. If you miss the deadline and you have a good cause for that, the government will forgive you for missing the deadline. But if you do file the application jointly, try not to miss the deadline. Usually, only those who file applications separately are forgiven for missing the deadline. You would ask, how is it possible to submit the application separately? When in fact it is possible. What's happening in a situation like that is that sometimes one spouse is no longer in a marriage. The marriage was real, but it fell apart. So the other spouse can proceed with what's called a waiver for the joint filing application, which is actually have to be submitted on the same form as a joint application for removal of condition, Form I-751. What happens next is that the government will have to make sure that the marriage was real at some point, but now it doesn't exist anymore. It means that the person will be required to show a divorce certificate. It means that those who are just separated and not divorced yet, those non-citizens will not be able to have their condition removed. So the government needs to have the government requires you to show the final point that the marriage was in fact ended before you will be able to have your application for removal of the condition granted. There are some other bases for the waiver. It means some other cases when you can file for application to remove condition from your green card without your US citizen spouse. One of those cases is when the US citizen spouse was abusive. Then the person is allowed to proceed by herself or himself. Another yet a ground for proceeding without your other spouse is when person stating that denial of the removal of the condition will cause extreme hardship to the person. So that's possible as well. If you are interested in the waiver grounds, you can look up Form I-751 that you can find on USCIS website. I need to say, however, that the instructions do not provide in depth what you really need to submit to prevail on those waiver grounds. And that is why at some point you will need to do research or consult with an attorney But the good news is that if you're no longer in a marriage, or the other spouse does not want to cooperate with you and file the joint request to remove condition, there is still a way out, and you may be able to prevail and receive your permanent green card. Now I would like to talk about one very important point. The conditional green card says it will expire at a certain point in time, and after that your status is no longer valid or terminated. I should say that this is not the case. The conditional permanent resident status cannot be taken away from a person by anybody except for an immigration judge. So what happens in a cases like that? When a person forgot or did not care about removing the condition on time or removing the condition at all, now they believe the status expired and they can just change the status or obtain a new green card with a new spouse. This is not the case. Whenever you would like to proceed or do anything on a new basis, and you were at some point a conditional resident status, at least based on marriage, you will have to have that status terminated first, or you will have to apply to removal of the condition and to get a permanent resident status without the condition on it, depending on your situation. So this is very important to know. And there are different ways how one can renounce that status. It may be in front of the immigration judge, or it may be overseas, in a consulate overseas, where you can surrender your green card status. But just because the card expires itself, you still have that status, even though you will have problems with employment authorization or I-9 form verifications for your employment and things like that. That status still remains. It's a very important point. So usually, let me just finish by explaining what is required and why some people sometimes can be called for I-751 interview. What's required to prevail on removal of the condition is any evidence that may help you to establish that you still have a real marriage with your spouse. Of course, USCIS likes copies of the birth certificate from children born in marriage, if you have those. Copies of big purchases, evidence of large purchases like a house or a car, something that involves a lot of money, showing that both spouses spent money together on that. Life insurance policies, when one of the spouses is listed as a beneficiary, 401k plans, wills, deeds, trusts, something that shows that the one spouse relies on the other spouse or tries to plan ahead for the other spouse. Of course, affidavits from friends and family members who can attest that you guys do have a real marriage and you live together. Those are always good. Copies of reservations from common traveling. Maybe you traveled overseas, maybe you traveled within the United States. It can be anything. And photos of you together. One more point. During this process, USCIS has a right to call you for an interview. It may happen because there was something wrong with your file or something wrong during the first interview, or it may happen just because it happened and there is nothing to worry about. If you do receive a notice for the interview for I-751 form after you filed, I advise you to talk to an attorney, and if you can, hire an attorney to go with you. Most likely there was some issue that you can address and fix before you go for an interview. But you will need to show that lawyer your file, what you submitted and what happened during the first green card application. I hope this video was helpful. You can read more about I-751 or removal of the condition on our website www.shalsova.com. You can always call with questions 917-885-2261. Thank you.